Welcome to our webinar on special needs planning. And we're going to go through a number of things today with regard to how to create a special needs plan, how to administer the plan, what the purposes of the plan are, and really how beneficial this can be to the person with the disability. We have a lot of self-directing disabled clients. We have clients who are disabled children, and we represent the parents. We have clients who are disabled parents, and we represent them and the children. So it has a lot of different varieties to it, but special needs planning has some themes that we'll cover with you today. And we are Pierro, Connor, and Strauss. I feel like I should do that as a cheer. We are PCS. And I'm going to introduce my partner, Peter Strauss, who is in our New York City office. Good morning, Peter.
Good morning, Lou. Good morning, everyone.
And these are the attorneys currently of Pierro, Connor, and Strauss. We are adding photos as we go. We have 12 lawyers split between two offices, primarily our Albany and New York City offices. And special needs is one of the areas that we focus on in addition to estate planning, tax planning, elder law, business succession planning. And Peter Strauss has one of the longest histories of any attorney practicing in the special needs area and one of the deepest knowledge bases. So I'm going to rely on him throughout the presentation today to get us all up to speed on this very essential practice area. So we'll cover special needs basics, the planning techniques that are available to us to accommodate special needs planning, the federal benefits that are so crucial to that individual with special needs, New York State Medicaid rules and the changes to Medicaid rules which impact this area of planning. Some new things that have come at us with regard to retirement accounts, which have created both some planning challenges and planning opportunities for individuals with special needs. And then for each of you, whether you're a professional counseling clients with regard to special needs planning or an individual who is interested, what the next steps might be. So with that, we are going to conduct a brief poll. And there are the polling questions. So this is the interactive portion of the program. So if you would take out your mouse and click your answers, we would like to get an idea on who we have today as the audience. So if you don't mind, if you would participate in the poll, we would very much appreciate that. And okay, are we sharing results? So we have a number of professionals, which is an audience that we draw frequently. We also have some caregivers and some people who are just here to learn. Welcome to all of you. And we would love to have follow-up dialogue with you, and we'll talk about that at the end of the program. But today, let's jump into it. And Peter, this is the essential area. And I know that you have such a strong passion for that, and that will come through. Why don't you take it from here?
Well, this is about carrying out your life's goals if you are a parent of a person with disabilities, to ensure their health and safety, which you do now. You are the caregivers in most cases. And for those professionals who are on today, you advise the caregivers. So this is about what happens when you can no longer do the caregiving, when you are no longer the people who are the hands-on caregivers, either because you become incapacitated or because you may die. And this is difficult. It's difficult to talk about. It's difficult to seek professional advice. And unfortunately, sometimes what you see on the internet isn't really very helpful. So what we're going to try to do today is give you the guidelines, some of the strategies and the benefits, and also tell you about the risks of not doing the planning, because they are serious and significant. So let's do it.
So the goals of special needs planning vary depending upon the individual circumstances. And Peter outlined what is probably the most common set of circumstances, and that is parents who are in the role of the caregiver for that disabled child. We have parents who are in their 80s and 90s whose children are in their 60s and 70s, and that role doesn't change. until it does. And once it does, then you have to have a plan in place. But we also have a number of working disabled clients that work under a variety of plans and programs. And for some of those programs, the income cap is extremely high, where you can still keep the medical benefit of Medicaid and work under one of those working disabled programs. And we've done, we have clients that are brilliant, and we've done some very creative planning with them to ensure that they keep the essential healthcare benefits that allow them to function and to work. But Peter, just if you would briefly go through the goals of a traditional special needs plan.
Well, the slide tells us what we need to talk about. We want to create a plan that works, that covers the personal care of the person with disabilities, handle the financial aspects if that is necessary, if the person is unable to manage their own finances, the legal planning for persons with disabilities. And we also have to look at how the needs of the person with disabilities affects the overall family unit. What are the psychological, emotional, and practical aspects of the caregiving, and how those needs can be met, how we can balance those needs. We need to let everyone in the plan world, in the family world, know about the plan. What are the goals? What would your role need to be if the parents have to step aside, whether it's the parents, grandparents, siblings, etc., who's able to undertake these responsibilities going forward? The structure may be there, but people need to manage that structure. So that's the communication part. We have to have a plan that is flexible. Circumstances may change. The beneficiary of this plan may improve. It may need to be simplified, perhaps even turn over to the person with disabilities if they improve, or that person might have more serious medical and psychological issues later on. And the bottom line is that this is to give you both peace of mind and harmony in the family, but also know that it will be secure and it will be flexible enough to bend with the winds of legislative changes and budgetary cuts and new developments for both the medical and psychological illnesses, but also social attitudes towards persons with disabilities.
So if you don't plan ahead, you get caught in a lot of vices and vice traps. So we don't want to have to go to court unless we need to. And in some cases where you have developmentally disabled individuals, you want to get a guardianship under 17A of the mental hygiene law before that child turns 18, because that's the age of emancipation, and it's very important to keep that in mind. But for the most part, we want to try to keep this as independent as possible. We use the documents that are available to us. Many people have disabilities, but have the ability to sign things like healthcare proxies, powers of attorney, wills and trusts. And so we want to keep in mind that the plan is there to protect against future needs, and it is a varied plan depending upon individual circumstances. And toward the end, we're going to talk about cases, Peter, that it's a moving target because the disability is not a set and fixed disability. There are conditions that fluctuate, and we have to build a plan flexible enough to accommodate that.
Correct. And the mantra that is overriding here, Lou, as I think many of the professionals know, and this language is built into Article 81 of the Mental Hygiene Law, which is the major guardianship program. The 17A is mostly in surrogates court for people who have developmental disabilities. The mantra is the plan has to provide the least restrictive alternative for the person with disabilities. And note, Lou and I have been very carefully not saying the disabled person, but the person with disabilities. And that you're going to see throughout this presentation. We focus on the person and that person's needs, not necessarily on the fact that they are, quote, disabled. They are people and they have rights. And to the extent that they can manage their own lives, the plan has to make that happen.
And very often we call them other abled because many of them have significant abilities and certain limitations. So other abled individuals is something that we utilize at times. I just want to point out one special needs technique. We're going to talk about special needs trust in some detail, but we're talking about parents planning for children. I am very lucky. God gave me 3 healthy 20-somethings, and they're all working. They're all very, very well positioned. They've got educations, and they're doing well. But I had a mom who had Alzheimer's. And you would say, well, your kids are fine. What do you need a special needs trust for? Well, in my own estate planning documents, because my mom had very limited means and she had Alzheimer's, which could be a disease that had a prolonged course and required significant care, I carved out a special needs trust for my mother as part of my documents so that if I predeceased her, the support that I gave my mother would be replaced by this special needs trust, which upon her passing would then flow back to my family. My mom has since passed, but just keep in mind that this tool, the special needs trust tool, applies in a variety of contexts and a variety of ages for the recipient and beneficiary. So, Peter, what are the steps?
Well, we call this a personal care plan. We combine legal and support services. We work with other members of the planning team to make sure that we cover all these bases. It certainly focuses on providing for the person with the disability. We want to make sure that the assets that the family will provide for this person is protected, and it is workable and it is accessible immediately when the caregivers are no longer able to provide that support, which is why we're going to be talking about trusts rather than setting up trust under wills, because there may be a delay if the trust is established under a will because of shortages of staff in the surrogates court and budgetary cuts and just the time it takes.
And the requirements for a guardian ad litem when you have an individual with special needs. So the court is going to appoint another attorney typically, and that attorney is going to have to conduct a thorough investigation and then file a report. And the court can't order the will admitted to probate until that report is filed.
Correct.
And that takes months. I had one that just got finalized. It's 10 months into the process after filing for probate. And we just got the guardian ad litem report and just got letters testamentary.
Correct. I have a client who died a year ago in the summer. It's now 1 year, and we still don't have the will probated because of complications from COVID and budget cuts and delays. Fortunately, we were able to get a temporary executor appointed, but it is a disaster. So we want to avoid that, and we can do that. And of course, we want to make sure that there are no loose ends. And what do I mean by that? We want to make sure that the assets do not need to be changed. The structure doesn't need to be changed if you don't change beneficiary designations on life insurance or retirement plans or joint bank accounts, or grandma has a bank account in trust for a 24-year-old grandchild who has disabilities and is receiving government benefits. That could be a disaster because that grandchild will now own money that makes her or him ineligible for benefits. So we're going to talk about all of that. So the plan has to really examine all aspects of what will be available. And we also have to deal with the emotional question of, if you've got 3 children, how much and what are the needs of the child who has the disabilities? Do they get 1/3 of your wealth when you die? Or do they need more? Do they need less? These are complicated questions that we need to discuss with our clients.
So the fundamentals, there are techniques that are specifically provided by federal law, and we want to maximize those available resources. Government benefits are available to all families, and what we are trying to get at there is some programs are not available other than through Medicaid, especially for people with developmental disabilities, the OPWDD programs. You can't buy in to those programs. So Medicaid becomes an essential requirement to get certain essential services. And there are ways that families can access those benefit programs. Personal resources serve as a secondary source of support. And Peter has cited cases here, the Olmstead case in matter of Shaw, and when push comes to shove, those are the cases that we rely on to argue for independence and the support of the individual in the most independent setting possible. So there are a lot of confusions that come up because of the SS words, SSDI, SSI. What type of benefit are you eligible for? Social Security disability is for people who have worked at least 14 working quarters. They've established a work history. They have an entitlement to a Social Security retirement benefit because of their work history. And now they're going to take that benefit early as a disability benefit. There is no means testing on Social Security disability. You can have as much money as you want and still qualify for that disability payment. Once you are disabled under the Social Security definition, which is used in most contexts here, 2 years later, you can qualify for Medicare, which is an important benefit, Medicare Parts A, B, C, and D, which provide physician coverage and hospitalizations, not long-term care. So, but Medicare is important, but does not cover the long-term care side of the benefit. Other benefits like the disabled adult child benefit. So you need to know what the programs are, what the eligibility rules are. And for these are not means tested. So you don't have to get down to the extraordinarily low levels of assets that you need for supplemental security income, or SSI. Some people qualify for both, Peter. Some people have an SSI and an SSDI benefit. And one of the things that we fundamentally ask for when clients come in for this type of a consultation is bring all of the letters that you've received from the Social Security Administration, because at the beginning of your benefit period, you received an award letter, which outlines what the exact benefits you are eligible for and what the dollar amounts are. And that is the seminal document, the foundation, Peter, upon which we build the plan.
Right. And I think what many people do not appreciate is that as great as Medicare is for seniors and younger persons who have disabilities and have been receiving SSD for some period of time, is that Medicare really fails that category of citizens because it doesn't cover long-term care. Yes, there is a nursing home benefit under Medicare. If you've been in the hospital, there are strict rules about that, and you go to a nursing home, you can get, in theory, up to 100 days of nursing home coverage if the care is skilled, not if you're just there because you have cognitive functionings. So most people don't get the 100 days. Theoretically, it's possible. But beyond that, and maybe a few days post-hospital of home care, Medicare fails the elderly. It really is a serious problem. And no politician has really ever addressed this. Hillary Clinton did raise it in her campaign, and President Biden's big Build Back Better plan does have some proposals for assisting seniors at home. And that's a major breakthrough that it's even being discussssed.
Yeah,
but
and
for
that
the
would also
long-term care, it's Medicaid.
Peter. So not just the elderly, but the elderly and individuals with disabilities.
Right.
Because it's the same Medicare benefit. And if you turn on the news today, you're going to hear people talking about Medicare dental coverage, Medicare optical coverage, things that currently are not part of the program that would be brought in under the Build Back Better Act. But those are all things that are covered by Medicaid. We call Medicaid the gold card because it takes care of virtually every need that that individual has.
Correct. And what we're going to point out as we go through this morning is Medicaid is means tested. And you can see on the last slide that you can't have more than $15,900 in countable resources. There are certain exemptions. Your primary residence may not count, depending on its value. In most states, New York, it's pretty high equity value cap. Your retirement funds, if you're in benefit payout status, they don't count the fund. The income has to be dealt with because there are income limitations, as you can see here. But we have ways to protect the income and the resources. but it is means tested. So, you know, you've got to deal with that issue.
So for SSI, it's a $2,000 asset limitation. And that's for people, again, who have no work history, who have a benefit that they've applied for with certain age restrictions. And SSI is a limited amount of income. It's about $794 a month. But Medicaid is a much broader program, and that's $15,900 in assets. So if you don't need SSI, your asset cap is $15,900. Income cap is $904 if you're in the community. And no one can live for a prolonged period of time on that amount of assets and income. And that's where the importance of special needs trusts come in. And we have to give you a heads up. We just did a webinar last Thursday, which is available on our website, on the changes to the Medicaid home care program. These are major changes both to the fiscal eligibility and the medical qualification for home care benefits. I commend that webinar to your viewing. It's important, and they're coming up. Some of these rules are being phased in November 8th, so it's impending rule changes on how you qualify with regard to the initial assessment, who does the assessment, how the assessment is structured, what the physician review panel is, and the physician is no longer your physician, it's now a state-appointed physician. The review panel, which would oversee certain cases of high utilization, also independent, to be appointed by the state. So those are major changes. Then the look back period, because right now there's no waiting period to qualify for Medicaid home care benefits. But if you transfer assets starting, we believe, April 1st of next year, if you transfer assets, you will be subject to a 2.5-year look back period before you qualify for Medicaid benefits. So when we talk about the first party special needs trust in a moment, remember this rule. The transfer rule didn't used to apply to home care, now will. And so that first party SNT for people under 65 is going to be a vital planning tool for that purpose.
This is serious. I mean, people really need to know this is a major change in New York's history of being the most generous state in America on providing Medicaid more easily accessible with very good home care benefits. Because of COVID and because the New York State budget is significantly made up of Medicaid expenses, we have these new rules, which we may call, you know, gatekeeper rules. They're clearly designed to reduce the amount of money that the state of New York pays for the Medicaid program. And facing this and facing it now, and if the family has not done the planning, these dates are critical, particularly the April 1st date. The November 8th effective sections are serious and will cause delays and reduction in individual benefits. But that plus the look back period that will start April 1st is extremely distressing, and people need to pay attention to it quickly.
Again, we would recommend that you view the video at pierrolaw.com video section. It's recent, it was just posted, and it covers all of these new rules and the implementation of the current rules and the impact of this 2.5-year look back period that will be imposed starting at some point next year. So far, Department of Health has said April 1 of 2022. So, Peter, this is a common mistake that families make. We see it all the time. They want to take the easy way out. They have a disabled child and they don't want to leave that child anything because of their benefits. So they leave it to the other kids, but that's wrong.
It's wrong and a serious mistake, because leaving it to the other child who has the disability, leaving it to the child, a sibling perhaps of the child that has the disability, just places great trust in that person. That person could have a divorce. That person could have bankruptcy. That person may go to Aqueduct.
They could die. They could get by a bus.
And then that money goes to that person's spouse and children, or whoever that person names under the will. And in most cases, it's not going to be put back in a trust for the sibling who has the disability. Don't do it. And we can't repeat that often enough. And unfortunately, we see it happen a great deal. Or that person who is going to hold the money for the sibling with a disability may also be incapacitated and be on Medicaid and SSI. And that person loses the benefits of their program. So the trust is the solution here.
And you see the gift wrap money there. The special needs trust is a gift from the government.
And it developed because of the advocacy of frankly, lawyers like us over the years, that we developed these devices, these legal devices, to allow the caregivers who will no longer be able to perform that function, both personally or financially, to set up trusts that will benefit the child with disabilities of any age, without the loss of government benefits, without the loss of their SSI or Medicaid, and provide trustworthy managers, the trustees, to ensure that that person's lifestyle and needs can be maintained, avoiding these problems that we discussed of the probate courts and the possibility of misuse by the beneficiary of money.
And the design of the special needs trust is not a one-size-fits-all. We're going to talk about the various types of trusts, but remember, the person that you're planning for, who is the person with the disability, may not be disabled. They may have tremendous abilities and be other able. So you want to craft a trust that takes into consideration the participation of the beneficiary. What roles can they play? What powers and duties can you provide them? And how can they participate meaningfully in their own trust? And the word that I use in this area is empowerment. We want the person who is a person with a disability to be empowered to the maximum extent possible, to live as independently as possible, and to have their needs met in a way that they can participate meaningfully in those needs. And the distinction here, Peter, can't be more stark between a third-party SNT and a first-party SNT.
Correct. And in explaining these different types of trusts, the underlying principle is we'd like to draw a balance between the amount of self-control that we can empower the person with the disability to have, without stepping over the line, that because of that authority that we'd like to give them, it would make the assets considered to belong to them and make them unable to obtain the government benefits. So this is line drawing. And that's the difference between these trusts. The third party trust is the trust created by the person whose funds are going to be placed in that trust, but not the funds of the person with the disability, who may have some earnings set aside, as long as they don't go over the caps to make them eligible. So this is the parents' money in the typical case that we'll be talking about today. The parents put the money in a trust. That's called the third party trust. Any benefits, for example, if a child has the disabilities resulting from an accident and there was a lawsuit, and that person obtained an award of several $100,000 as a result of that accident, those are the funds that belong to the person with disabilities, the plaintiff in the lawsuit. That goes into the trust that he or she creates by themselves, and that's called a first party trust. A pool trust, the pooled supplemental needs trust, deals with the income, since, as Lou mentioned earlier, if you're on Medicaid, you're only allowed, and living in the community, living at home, you're only allowed to keep $903 a month of your income. So if your Social Security is $1,903, you have $1,000, quote, excess income. Normally, you'd have to contribute that to the cost of your government program. But by putting it in a so-called pool trust managed by a not-for-profit organization, that income can be protected and used for your expenses. So let's move forward and look in greater detail about these trusts.
So trust distributions are made by the trustee in either case, or any of the three cases. They must be made directly to the providers of goods and services, and that very often is accommodated with a credit card. So charges are made against a credit card, and that credit card can pay the appropriate charges and pay the credit card company at the end of the month. Money paid directly to the beneficiary for purposes of SSI will be considered, and for Medicaid will be considered in-kind income. So we don't want to make payments directly to the beneficiary, and the trust must be discretionary. It is a discretionary trust, not a mandatory support trust. So we don't want money having to be paid out. We want the trustee to have discretion. So before we dig into the details on that, I want to take a brief poll and ask the question, what is the difference between the first and third party trust? So get your mouse back out, and if you would, take a shot. See what you think on these questions. And more than one answer can be correct. So this is not a multiple choice. This is A, B, and C, A and B, B and C. All the above, none of the above. All right. So pretty smart audience. We have, most people know that who is allowed to form the trust is one of the distinctions, and that the payback requirement is part of a first party trust, but not a third party trust. But as I mentioned earlier, the third party special needs trust I created for my mom, who at the time was in her 80s. And so the age of the beneficiary is not determinative of the type of trust. Peter?
That's right. But for a first party trust, under current law, it can only be created by a person under the age of 65.
Correct.
So that option is not available for a person over that age. And this is something we need to be very cautious about.
So that was the wording, for whom the trust is created versus who can create the trust.
Right. The big difference.
Big difference.
Right. So we need to be careful. So again, it comes back, we're trying to draw that line between assets that the person who has the disability may own and the money of the parent, which would normally go into a third party trust.
So there are the results. And moving on. Let's take a look at the people that are part of the SNT, Peter.
Correct. So the person who establishes the trust is called the settlor or the grantor. Sometimes you'll see the term trustor, but that means the person who establishes the trust. The beneficiary in the area that we're talking about today is the person who receives the benefits of the Supplemental Needs Trust. And that's the beneficiary. And those benefits can be distributions of income or using the principal, but again, not paying it directly from the third party trust to that person outright, but by providing them with the goods and services, paying for their rent, their food, their transportation costs, medical expenses that are not covered by the Medicaid program. To some extent, if the trust pays for their housing or their food, there might be a reduction, probably will be a reduction in their SSI benefit. That's unavoidable. But for the most part, you don't want to make any distributions outright. No monthly allowance in a regular amount. So who else is involved? Again, this points out that the trustee is the one in charge. And again, it would be wonderful if we could consult with the beneficiary about his or her needs. In many cases, that's possible, and it's certainly desirable. Again, who else is involved here? We work closely, and we have an affiliated firm that is a care management company. So we need a care manager with other kinds of advocates. And there is something called a trust protector this is an independent individual who can serve as part of the trust structure and make certain legally allowable changes in the structure and terms of the trust as time goes on, where perhaps the trustee isn't able to do that, to have those authorities. So this again is a team effort.
The Special Needs Trust is following modern trust drafting concepts. Trust protectors in American jurisprudence are relatively new. They've been used in other countries and in other jurisdictions for many, many years, hundreds of years. But in American trust drafting, the trust protector is a somewhat new concept. We use it both in New York and in other states where we draft trusts. We call it a trust advisor in New York because that's been the nomenclature used here most often. But it's an important role, and it's an independent person who has the ability to tailor the trust at a later date. If laws change, if circumstances change, the trust protector is an independent party who will not jeopardize government benefits simply because they have the ability to amend the trust and to make certain changes. They could even be given the power to terminate the trust, provided it's an independent party, and we're very careful in drafting. The advocate or care manager could also turn into a committee. And if you have a situation where the creators of the trust want to create a team of people who would inform the trustee as to the needs of the beneficiary, that very often could be a family member and the care manager, or the advocate, or the case representative, because many people who are in the state system or other systems will have a case manager. You can form a committee to advise the trustee on the needs and how to expend the funds of the trust. That, Peter, really becomes part of that care plan that you mentioned right at the outset, to bring into the planning the legal side with a trustee empowered properly, a trust protector to oversee that and be able to modify the document, but a care team that can inform both of those individuals as to the needs of the beneficiary that are, again, changing over time, to make sure that the trust is fulfilling its essential purpose. So let's dig into the first party SNT, Peter. And I remember hearing a gentleman talk about this back 1993, 94, because this came in through the Omnibus Budget Reconciliation Act of 1993. And his comments were, this statute was written by the four horsemen of the apocalypse. And that was none other than Peter Strauss. What do you mean by that?
Well, it was a breakthrough in some respects, but it was so restrictive, and there were some really idiotic and silly parts to it. For example, when it was first created, the person with the disabilities couldn't establish the trust that would house their own money. The trust at that time under the original law said it can only be created by a parent, guardian, or grandparent.
Or court.
Or court. Why did they leave out the person with disabilities? And I kept saying, people looked at me, kind of cross-eyed. I said, because members of Congress thought that if you had a disability, you were incompetent. They couldn't understand that there were people with disabilities who functioned very well in our society, and this took away their rights. They couldn't protect their own assets. So we had to go to court in many cases, because if they were older and their parents were not alive, that was the remedy. Well, we finally changed that.
Guardianship.
Yeah, we finally changed that law a couple of years ago. So now the person with the disability can create his or her own trust along with the parent, grandparent, guardian, or court if they were not capable of doing that. So that's a little bit of history.
And I'll give a shout out to, because the National Academy of Elder Law Attorneys had a significant role in liberalizing that, and also my partner Michael Amoruso, who himself has a disability but is one of the highest functioning elder law attorneys in the country. He was the president of NALA at the time and was part of the signing ceremony of that statute. So Michael was a tremendous advocate to get that law changed. So we'll give him some kudos for that.
Well deserved. Well deserved.
This trust is, again, created with the individual's own assets, and that may be an inheritance. And, grandma left money to Billy, and Billy has a disability that he needs Medicaid and SSI for, but grandma left it right to Billy instead of putting it in trust for him. Billy now needs a first-party SNT. People who get personal injury settlements, people who earn money, as Peter said, and need to contribute to a first-party special needs trust.
Or the parent forgot that they named the person with disabilities as one of 3 beneficiaries on a life insurance policy. It just got overlooked. And of course, we're very careful about that when we work with clients doing the planning. Those loose ends have to be attended to. So that
and the other major concept is disability doesn't always onset at birth. You may be working, you're on the work site, you have a workplace accident, you get hit in the head, you have a traumatic brain injury, and you now need Medicaid. That person will maybe have savings, they'll have retirement accounts, they'll have other money. That money has to be protected, and as long as they're under 65, they can use that first-party special needs trust, which will be irrevocable. We talked about who can create it. You can fund it with the individual's own assets. Nobody else should be putting money into that trust. And those are all of the different times when that money may come into that person's hands, or the disability onsets suddenly and they have assets that need to be sheltered. And Peter, the key here is once you put those into the special needs trust, there is no waiting period or penalty period, and the money is immediately available to pay for those supplemental needs.
Correct. Now let's just for a moment mention the major disadvantage of the first party trust. At the time of the death of the beneficiary, the state must be repaid for its Medicaid expenses over the lifetime of that beneficiary. So we can't avoid that. The payback requirement has to be provided for in the drafting and creation of that trust. But there is something that people need to think about. It's very common that there is this first party trust funded with the money of the person with disabilities, and also a third party trust created by the parents. Well, use the money of the first party trust first before using the money that has the funds of the parents, because there's no payback requirement in the third party trust. So it would be better, since either trust can probably pay for the same expenses, let's spend down the first party trust so that family is not deprived of that benefit because of the payback. And remember, the beneficiary of the first party trust may also have a spouse who has a disability or a child with a disability. So we want that parent's third party trust to continue to be in existence to the maximum extent possible. And that trust could provide for those secondary beneficiaries later on when the person we're talking about here is no longer around.
And most states require notice. You don't have to ask permission to make distributions, but you have to notify the state if you've made substantial distribution and depletion of the trust. You have to register the first party trust with the state and the county in New York. You have to go through the county departments of social services. And the types of distributions are still pretty liberal. It's all governed by federal law. The program operations manual system, PALMS, for the Social Security Administration governs the treatment of first party special needs trusts.
And these PALMS rules about how the first party trust money could be spent were extremely restrictive under prior administrations. Within recent years, the government has loosened up these rules. Let me give you an example. If the beneficiary of a first party trust was in a wheelchair, perhaps, cognitively fine, wants to go on a vacation, needs the aid to go along, there was always a fight over whether you could use the first party trust to pay for the aide's airline ticket. Those rules have been liberalized. They're much more flexible now, and the government has allowed the states to be much more realistic about the kinds of expenses that are for the sole benefit of the trust beneficiary. I had many cases over the years where a child had a brain injury from birth. It took 10 years to achieve a settlement. A fund of money came in. We had to create a first-party trust for that child, perhaps through a guardianship. And the mother wanted to move to a larger apartment because she had several children. And there would be a fight over whether a higher rent would be permissible from the funds in the first-party trust. We used to lose some of those cases. Now we think we're in much better shape legally because of the liberalization of the POMS rules.
Well said. Peter, we have about 10 minutes left. The third-party trusts are where my passions lie because you get to be a creative draftsperson in the third-party trust world. And you can slice and dice trusts that are third-party trusts. The premise here legally is that when you have assets and you're creating a trust, you're trying to put those assets of your own out of the reach of creditors, and in this case, Medicaid. And New York has a public policy against first-party self-settled asset protection. They don't want us to be able to create a trust and protect our own assets with that trust from creditors. The Special Needs Trust is a federal exception to that general rule. But if the assets are not my assets, if it's my parent or my child who wants to leave assets to me, any third party, there are very few restrictions on how that trust can be drafted and created and have those assets protected for Medicaid purposes, SSI purposes. And in our office, we draft a lot of these trusts to protect children from divorces, from creditors, from lawsuits, from bankruptcies. New York public policy does allow all of that in a third-party trust. So it's someone else's money creating a trust and funding it for the purposes of a third party. The beneficiary here can be any age. The grantor can be any age. Trust assets can be used as the trust directs. So we very often have one special needs beneficiary and other non-special needs beneficiaries of the same trust. They call it a pot trust, where you have 3 kids and you want the money to be used by whoever has the greatest need, whether it's a disabled child or not. Special needs provisions would apply to the disabled child. So we can be tremendously creative with third-party trusts. Again, it's a discretionary trust. The trustee has the ability to use the money for virtually any need that that person has, that beneficiary has. And as Peter hammered out, no payback requirement. So if we have 3 kids, one has special needs, the money goes into that special needs trust. During the disabled child's lifetime, it's used to support, supplement, and not replace the government entitlement. But at the child's death, it then passes back to the other 2 children. And this can be done in a will, but as Peter said, a will ties us up in probate. So we are often doing these through either revocable living trusts or Medicaid asset protection trusts, or sometimes a standalone third-party special needs trusts, because sometimes not only the parents, but the grandparents, the aunts, the uncles, may all want to leave something to that person with the disability. And if you have a standalone trust, everybody's document can target that trust as the beneficiary of whatever benefits they want to leave, or a life insurance policy or a retirement account. They can name that standalone trust. We create that immediately. It's there and it's funded, and it can be a receptacle for not only the parents, but also the grandparents, aunts, and uncles for that same child. Peter?
I want to point out here that, because again, we are running out of time, the drafting, the specific wording of these trusts is critical. It's very easy to have provisions in a trust that is intended to protect assets, whether it's a first-party trust or a third-party trust, that can run afoul of provisions of the law. Lou mentioned earlier that you need to use only discretionary language rather than support language. What do I mean by that? If the trust, a third-party trust, says you can spend income and principal for the health, education, support, and maintenance of a child with a disability, the government may take the position that that's creating rights in that beneficiary to create a demand that the beneficiary could make on the trustees. And because they have that right to sue to enforce that very broad provision, the trust could be deemed to be countable and belonging to the beneficiary for Medicaid eligibility purposes. If you just say discretionary trust, that the distribution powers are totally discretionary, we don't have that problem. It seems like semantics, but it's not. And I bring this up to caution you. I don't want to say just you must go to a lawyer, but there is a risk in using these online documents. There are a lot of companies now, and maybe they work, but in many cases they won't. So I strongly believe you need the advice of some people, some lawyers who have experience with drafting these trusts, because it's very easy to make a mistake. I was handed a trust yesterday. It's a perfectly good third-party trust, but it doesn't say who's going to get the money. There's no distribution provision in it. Some lawyer didn't draft that trust properly, and now we have problems. So you must go to someone with experience to avoid these pitfalls.
Couldn't agree more. I think we've covered this. Living trusts are far superior in this context to a will for all of the reasons stated here. We won't go over those. Special needs persons and siblings, we want to strike a good balance and make sure that we continue that balance. I have a lot of clients who have children in the OPWDD system. They're in residential facilities. Their needs are fully met by the state benefit. They may not need a full 50% share if there are 2 children. You want to set aside some money. And what I tell them is, well, that government program may not always provide exactly what they need, so you shouldn't cut them out. But it's a balancing act, Peter, when you're looking at all of the different family members and the needs of each one.
Correct. And if there isn't a lot of money in the family, and you do feel that there has to be some significant provisions for the child with disabilities because you're not sure about what the future will bring, life insurance may be a solution here. If you can afford the premiums, and if you buy it at a young age, and the policy perhaps is one that doesn't kick in until both parents have died, because the premiums for that kind of policy should be a little bit less expensive, that life insurance could fund this freestanding supplemental needs trust for the child, as well as some percentage of other assets that the family has.
All right, we have 5 minutes and about 13 slides left. So I'm going to go a little bit more quickly, and I'm going to hold back war stories. Empowering a child, this is a passion of mine because we deal a lot with the National Alliance for the Mentally Ill, NAMI New York, and dealing with children who have varying degrees of capability and capacity. It may be schizophrenia, it may be bipolar. We want to create that trust that we want to empower that individual. And with good drafting, a third-party trust can accomplish that goal by balancing the needs of the beneficiary with the desires of the parent to make sure that the funds that they're leaving in trust are going to be well managed and protected. So these types of trusts can use that trust protector or a committee, as we said earlier, to toggle on and off certain rights and powers of the beneficiary. And we call it an empowerment trust. That's just our own convention. But I think it's a descriptive name that works. And we want to make sure we have the right trustee, the right trust protector, and a committee. Sometimes we include a physician on that committee to be the decision maker, their primary physician, or their caseworker, or their PA, to make sure that we have structure in the context of that beneficiary's own life that's meaningful for them. But empowering children and protecting them at the same time is possible, but you're not going to get this in an off-the-shelf document, Peter. So selecting a trustee. Peter?
The critical issue. It's very important. Some family members, some children will have better experience and capabilities on the financial issues. Another child may have better experience and instincts on personal care needs and decisions about where a child should live. You can have a financial advisor, perhaps as a co-trustee, an attorney. You have to think about who's going to make the controlling decisions. Remember, trustees or a committee will probably have to act by majority vote. Be careful. We all love our children and we expect them all to be trustworthy, but I have to point out that a lot of financial abuse on the elderly and persons with disabilities does come from family members. So you need a lot of discussion, and this sometimes is the biggest and longest part of our conversations with clients, just it is on who is going to be the healthcare agent. And it may be that the persons who are going to be beneficiaries of supplemental needs trust could execute a healthcare proxy. Capacity is not an on-off switch. And so empowerment is important. And capacity, as I just said, is not all or nothing. So bring the family in, but be careful about who has the decision-making authority.
And in certain cases, we will use a professional trustee. And sometimes they're a co-trustee with a family member. Sometimes the corporate trustee will run the trust and have a trust protector oversee their activity. This is where we would sometimes put that committee in to guide the corporate trustee. But with a corporate fiduciary, you get stability, continuity, you get professional guidance on investment management, and you get a professional trustee to make the distributions who is going to be knowledgeable about those benefits, the Medicaid and SSI benefits, and make the distributions in the appropriate way. Not all trust companies are created equal. Offline, we'll tell you who we think are the good ones, but some really have a niche practice in special needs trusts.
And some actually have care managers on staff or social workers to assist them in carrying out the duties with special needs trustee beneficiaries.
It's important that not only the assets that are funded into a living trust or you're going through your will, but also other assets like retirement accounts, life insurance, annuities that have beneficiary designations. You have to make sure that you thread all of those things in and change the beneficiaries so that nothing gets outside the trust. We don't have outlier assets that go directly to a beneficiary. You want everything to funnel through the trust. And as Peter mentioned, especially for younger couples who have a disabled child, life insurance is absolutely essential. And it's inexpensive, and it should be part of the future care plan and special needs plan to fund the needs of that disabled child. And you know, we could go in and have a whole day on life insurance planning. Suffice it to say that it's an essential tool in special needs planning for those clients that don't have the full ability to fund a special needs trust and take care of all of the needs that that beneficiary may have. Peter, we got a little curveball from the government.
We did.
That came in January 1 of 2020. That is the Secure Act. And nobody feels more secure because of the Secure Act. What it was designed to do was to squeeze $12 trillion out of retirement accounts faster upon the death of the IRA owner and participant. And it does that by saying, okay, when you die and you leave this IRA, you have $1 million in your IRA, you leave it to your kids. Under old law, they could stretch it out and take it over their life expectancies. And we got very clever, and this is what Congress didn't like. And we would name grandchildren and trusts for grandchildren who had 70-year life expectancies. And it continued the tax deferral. The government didn't get their payday. So now you have to take it out over 10 years. And that means that all of that money gets squeezed out of the retirement account over 10 years with certain very important exceptions. And Peter, one of those is for people who are either chronically ill or have special needs.
Correct. So basically, one thing that we consider with our clients, and the calculations might be very complicated, but if there are 3 children, and maybe we should consider, depending on how the numbers work out, and here's where we would have to consult with the financial advisor and the accountant, maybe shift more of the retirement funds into a trust for a child with disabilities where we could have the lifetime stretch, where the income tax savings over that person's lifetime could be significant, and less of the and more of the other assets to the other children. It's not going to work in every case, but it is a possible planning opportunity to continue to stretch out some of that money and minimize income taxes, which are going to be going up to some extent for many of us. I hope you're in the category where you'll have to pay more income taxes. That would be perhaps wonderful.
Good
But
news.
again, that's something. So you can see there are many aspects to the planning for these supplemental needs trusts.
And so IRA provisions need to be drafted into an SNT if you're going to name it as the beneficiary of a retirement account. And those provisions will have certain abilities to accumulate money and to deal with the tax implications of it being a retirement fund receptacle. But it gives you the ability to stretch the benefits over the life expectancy of the disabled beneficiary. And that is a very good result, both from the perspective of tax planning and funding the special needs trust and preserving the benefits of that beneficiary. This is a newer topic than special needs trust, but not totally new. Able accounts, Peter, that's something that has come on the landscape in the last several years and a great benefit.
It is, and it has flexibility. We could put aside, I think on the next slide, we're going to say that I think in New York, you can put in up to $100,000 total without it interfering with your SSI benefit. You can put your annual exclusion gifts in there, and they work well. The disadvantage is, like with first party trusts, it has a payback provision. So you really need to make sure that you're going to be able to use up that money. Otherwise, you're going to lose it at the end. It's a niche benefit for some people, and it may allow a person who has the ability to do a lot of their own planning and control their own lives. It might be useful for them. And so it's a piece of the puzzle when we counsel a client on the best way to protect children with disabilities.
And these are now widely available. In the beginning, when they first came out, there were only a few of them available, but now many institutions have ABLE accounts, and the availability to access ABLE accounts. A lot of people think of them like 529 plans. You're putting money away for a particular purpose, and you get some advantages from a tax perspective on that as well. So ABLE accounts should be part of the consideration when you're doing the planning, and it's an opportunity to put money aside in a very creative way using this new tool. Again, a gift from the government. You don't look a gift horse in the mouth. This is something they've given us to plan for people with disabilities, and it's something that's very, very important. So how do you get started? What are the next steps? Get your team together. And the team can be pulled together from people you're already working with, the case manager, your accountant, your financial advisor, and a lawyer or a law firm that has an expertise in special needs planning. You want that financial advisor to talk about the financial plan and the life insurance, if that's going to be part of the plan. The attorney is going to talk to you about the legal planning, your will, trust, hopefully revocable or irrevocable trust for yourself that morph then into a special needs trust, how to bring all of those benefits together upon your death so that it funds the appropriate trusts for your various beneficiaries, including the special needs trust. And then I think one of the most important things that people need to do that have children with a disability is to really sit down and think through, what if I were erased from the equation? What if I wasn't here to provide services to my child? Who would do that? How would they do it? How would it get financed if it was a paid benefit? And those are very, very important considerations. And when we construct trusts that have the funds to support the individual, the future care plan is a document that informs the trustees and helps that trustee to administer the trust appropriately.
And I would add just one more final thought. You're not just planning for your child with disabilities. You have to plan to protect your own assets so there will be funds left to support the child with disabilities for his or her lifetime. So don't neglect your own planning and see how that could be dealt with in the event you were to become incapacitated or ill, not just die.